You're sitting there wondering whether or not you should pay collections or charge-offs. You are at the right spot because in today's conversation, I'm going to give you 10 reasons why you should not pay collections or charge-offs and what you should do instead. Don't go anywhere. You're going to love today's conversation. I guarantee it. Welcome, folks, to another edition of the Awesome Sweetie Kiwi Show. How are you today? I hope you're all doing fantastic. I'm doing marvelous, if you were to ask me. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. In today's conversation, I want to talk to you about why you should never pay collections or charge-offs. And I'm going to give you 10 reasons why and what you should do instead. Before we get into the nitty-gritty, folks, what exactly is a charge-off? So if you haven't made a minimum payment for more than 180 days, that's 6 months, your lender will likely consider your account a charge-off, essentially declaring it's no longer an asset. So when creditors charge off accounts, they're marking it as a loss in their balance sheet and they write it off their accounting books. As a result, the creditor might owe the federal government a little less. Many consumers have the misconception that a charge-off means that they no longer owe the balance. No, you got it wrong. Your account will be closed though, and interest will stop accruing on your balance, and you will not be able to make new purchases on the accounts. This doesn't mean you are off the hook for what you owe. Very important to know. So let me ask you a question. Big decision time. Talk to me. Do you still have to pay a charge-off credit card? Right now, if you have a charge-off account, do you still need to pay it? The thing is, the answer is yes. Even though the credit card issuer has declared a loss on your account, you are still responsible for repaying the debt. No questions about that. The creditor can and probably will still attempt to collect the debt and might even assign or sell the debt to a third-party debt collector who will pick up the collection activities. And we know how hard those debt collectors can be sometimes, right? And at the end of the day, rather than having the convenience of paying your balance over time, the full balance of the charge-off is due. You may be able to negotiate with the creditor for a short-term installment plan, but this is ultimately at the creditor's or the collection agency's discretion. It all depends on how likely they think they are going to get something from you, some moolah from you, some cash from you. The thing here is that you got to think about the best way to go about the whole thing. How do you decide if you should pay a debt collection agency? There are several factors, and I'll talk about that later on in the show. There's several factors you need to take into account. But one thing I want to say here is that what if you don't pay your charge-off? If you choose not to pay the charge-off, it will continue to be listed as an outstanding debt on your credit report. As long as the charge-off remains unpaid, you may have trouble getting approved for credit cards, loans, or other credit-based services like an apartment. One thing I want to say here is that this show, I'm not telling you that you should never pay collections or charges. I'm giving you 10 reasons why you might choose not to and what you should do instead. Okay? It has to be clear in everybody's mind. Now, let's talk about the top 10 reasons why you may consider not paying collections or charge-off. Number 1, damage is already done. Think about it. Your creditor will report the amount and the charge-off status to the credit bureaus, and they will include it on your credit report. So the damage is already done. So the charge-off status will remain on your credit report for the full credit reporting time limit, which is 7 years from the date of the charge-offs, whether or not you pay it off. Okay, so damage is already done. You pay it, you don't pay it, it will sit there. The derogatory item will sit on your another balance sheet, on your credit report for 7 years. And one thing you need to understand is that old debts can cause problems whether you pay or not. And so if the damage is already done, why are you rushing to pay it off? Why not save that money and do something else with it, right? Especially if cash is tight, if you are going through some liquidity problems, you better be very strategic about how you use your money. What I'm trying to say here is that the collection agencies will not stop calling you. They will be bothering you. They will call you. They will just make your life, quote unquote, miserable. But if you can withstand those calls, then you should be okay. Reasons number two why you may consider not paying collections or charge-off. The FICO removal is nearly impossible. In other words, the regulatory item on your FICO credit report is nearly impossible. Let me ask you a question. Do you currently have some items on your FICO that you would want to be removed? Talk to me. Talk to me. Do you? Well, if you do, let me just give you the good news and the bad news. Good news, it is possible. Bad news, it is nearly impossible. I know there's some kind of dichotomy here, but the good news is it is possible if the item is inaccurate. In other words, if you don't owe the amount or it was done as a result of fraud or error, you can dispute the item. You can actually contact Experian, TransUnion, or Equifax, or the lender who supplied the information in the first place, and you can ask them to actually retract. You can ask them to correct the error. But hey, you better be ready. You better be sure that this is an error, okay? Because if it's not, they're not going to change it. They're not going to remove it, okay? So if it's an error or something that was inaccurately reported, by law, those three credit bureaus, in addition to your supplier, to your lenders, have a responsibility, a legal responsibility to remove the item. Reasons number three, the collector may not own the debt. Do you hear that? So the person who is calling you, the agency who's the debt collection agency who's bothering you at midnight or 2 a.m, debt collection agency, yeah, that one, they may not own the debt because debt collection agencies buy your debt from lenders. Let me just break it down. So debt seems like a fact of life for many Americans, right? Been there, done that. 4 out of 5 Americans, that's 80% owe some debts. So the thing here is that there are usually two parties in debt collection cases. First, there is the party who allegedly owes money, called the debtor. That's you. Then there's the party to whom the money is allegedly owed. This party is known as the creditor. So often a lender finds that they cannot collect the debt from a borrower. So interest keeps piling up on the borrower's loan, and there is no money coming in to pay it. So a lender then has two options, okay? A lender, in this case, Chase, Bank of America, or whatever lender. So they have two options. Either they collect the debt themselves or they sell it to a debt collection agency. Now, if you are a lender, you have to be very strategic here, right? Where do you allocate your resources? Do you allocate more resources on a debt that may never be collected, or do you want to zero in on those debts that can be collected and focus on them? So if they collect the debt themselves, tracking down an alleged borrower can become more of a hassle for the lenders than it's worth, okay? But if they sell it, that's kind of cool, because if they sell it to a debt collection agency, the lenders in this case are giving up their right to collect the debt but still receive some money. In other words, they're just selling maybe a 10 cents on a dollar, for example. It's because this helps lenders to recoup some of their losses. A debt collection agency is basically a company that buys unpaid debt from a creditor, okay? And they usually buys this debt for pennies on the dollar. Then they attempt to track down a debtor, a borrower, and force them to pay. This is why you get those nasty, repetitive phone calls. If the collection agency cannot show ownership of the debts, this is where the sweet things happen here, folks. If they cannot show ownership of the debt, then you don't own it. You don't owe it, rather. A collection agency hounding you may not be able to show they actually own your debt. If they cannot, then you are not obligated to pay them. Okay? Reason number 3, collector may not own the debt. Reason number 4, debt validation letters always rock. Oh God, they always rock. So if you don't owe the debts, rule number 1, please do not pay people money you don't owe them. Because if an agency is going after you for a debt you don't owe, send them a debt validation letter to get them off your tail. Let me ask you a question, big decision time. Do you know what a debt validation letter is? Have you used it before? Do you know how powerful it can be? Talk to me. Because, my friend, what it is that a debt validation letter can do a lot of good things for you because it is what a debt collector sends you to prove that you owe them money. This letter shows you the details of a specific debt, outlines what you owe, who you owe it to, and when they need you to pay. Legally, a debt collector has to send you a debt validation letter within 5 days of their first contact with you. And if not, you should ask for one. Why? Because it helps you determine if the debt is actually yours and if there is anything fishy going around here, right? And remember, when we talk about debt collectors, fishy is their middle name. Everything is possible. Just because it looks official, I'm talking about the letter here, doesn't mean it's your bills to pay. Either the bill or the letter, okay? So I'm showing you on the screen right now, courtesy of a USA credit lawyer, a simple debt validation letter. So we have 4 slides. So you have the first slides, and then you have the second slides, and then you have the third slides, and then you have the fourth slides. So again, this simple debt validation letter is courtesy of USA Credit Lawyer. Their website is usacreditlawyer.com. You can go there, maybe you can just download a free copy. That will help you. Now, this is important, folks. Why do you need a debt validation letter in the first place? This is because in 2020, the FTC, the Federal Trade Commission, received about 85,000 complaints. You heard that right. 85,000 complaints from consumers across the country about debt collectors, and a whopping 49% of those complaints were to report attempts to collect debt they did not owe. Think about that. There's a lot of scams going on in the industry. Talk to me about it. Talk to me about it. So that's definitely not okay. So what I'm trying to say here is that there is a chance, there is a possibility that the debt you are forced to pay may not be legit. So why are you giving your hard-earned moolah, your hard-earned cash to someone who doesn't deserve it in the first place? This is why you need a debt validation letter. Period. Question closed. Okay. So be very straightforward, be very steadfast on that. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of the Awesome Sweetie Kiwi Show. I'm still talking to you about the fact that you should never pay, or you should consider not paying collections or charge-offs. And I'm giving you 10 reasons why and what you should do instead. Reason number 5, you want to write a debt verification letter. This is another sweetie that you need to pay attention to. Now, we're speaking about debt validation versus debt verification, blah, blah, blah. What's the difference? The debt validation letter is the document you get from the debt collector outlining what you owe, who you owe it to, and important information about next steps. I've already explained that to you in the last section, right? The debt verification letter is a letter you write and send to the debt collector disputing the debt if you truly don't owe it or owe as much as the collector says you do. You will also send the letter via certified mail with a return receipt request, the 3R, so you have a record of your communication back to the collector. Remember, you need to send it with a return receipt request. Don't disappoint me. You better follow that. So the thing here is that those two letters, debt verification, debt validation, they have similar names, but they have very different goals. I want you to look right now on the screen. Check this out on the screen right now. And you can see the compare and contrast between debt validation on one end, right? And debt verification. Who sends it, what it does, what it says, how much time to respond, all that kind of stuff. We're going to leave this on the screen for a while so you can see it. So debt validation, the debt collector sends it. Debt verification, you, the borrower, sends it. What does it say? Validation letter outlines the specifics of your debts. Verification letter formally disputes the information in the debt validation letter. A debt validation letter, debt collectors are legally required to send one within 5 days of first contact, and you, as a borrower, have 30 days from receiving a debt validation letter to send a debt verification letter. So basically, a debt validation letter comes before a debt verification letter. It's just your response to the debt validation letter. And how do you write a debt verification letter? It's not really that complicated. Just make sure that you provide information such as the proof that this debt really belongs to you, like a signed contract. Like if you don't have anything that shows that, then state it. You want to state that this debt has no contract that shows that it really belongs to you. Make sure that you question how much you owe based on the last statement or bill. You can also say that the debt is past due because of the statute of limitations. You can talk about the last action taken on the account and prove that the debt collector has the legal rights and license to pursue this debt in your state. In your state. Very important. I want you to write it down. Write that down, in your state. So those are things you need to actually question in your debt verification letter. Reason number 6, folks, why you may consider not paying collections or charge-offs. You plan to settle the debts for less, right? Talk to me here. I mean, if your plan is just to settle the debt and you're just trying to buy time, then time is money. So if it is part of your strategy to settle the debt for less, then that's kind of cool too. So you can send the collector a debt validation letter or debt verification letter, and that will drag things down a little bit. But one thing that's very important is that once you send that letter to the debt collector, they might sue you. If they sue you for the debt, you need to respond with an answer to a summons and complaint. This may force them to give up or to settle the debt for less. Let me ask you a question. Big decision time here. Do you know what are a summons and complaints? No, right? Okay. A summons comes from a plaintiff. So the person suing you, the person initiating a lawsuit, will actually go through the court, and their statements, they will write a statement. So they will write a statement telling the judge what the problem is and what they want. That statement is the complaint. The person starting the lawsuit is the plaintiff. Okay. And so once they actually do a complaint, you're going to have to receive a summons from the court. And the summons will say you have a right to disagree with the complaint in writing, how long you have to answer the complaint. So you have 20 days from the date the complaint is handed to you or someone in your home, not 20 days from the date stamped on the summons and complaint. So a summons is not really a notice of a court hearing date. It gives you instructions about how to respond to the complaint. So if you don't tell the court in writing that you disagree with the statements of the complaint, the judge will assume that you agree with it and will often give plaintiff what plaintiff is asking for. In this case, the debt collection agency. So you really want to answer that. Now, when it comes to answering the summons and complaints, you can either answer the summons in writing or in person. Let's say if you answer in person, you must go to the courthouse clerk's office and tell the clerk about your defenses to the plaintiff's claims. Okay, so the bottom line here is that if this is too complicated for you, you can get a lawyer, or you can do it yourself, or you can ask us privately in our private email, and we'll just go a little deeper into the conversation. But there are several different defenses you can assert in your answer depending on the facts of your situation, including that you don't owe the money, you are the victim of identity theft, you already paid the debt, the amount of the debt is incorrect, the plaintiff, in other words, the debt collection agency, does not own the debt, the collection agency has no license to collect the debt, the complaint does not show the debt collection license number, okay, the statute of limitation has passed, and the debt is too old to collect, the debt was discharged in bankruptcy, the agreement related to the debt is unconscionable or shockingly unfair, you are in the military, or your debt arose out of work done by a home improvement contractor who was not licensed, and or had you signed a defective contract according to the home improvement statute. So here, this is just a repertoire of possible reasons you can raise in your answer to the summons and complaints that will help you. Reason number 7, if the statute of limitations has expired. I love that. Because guess what? Somebody might be calling your house and bugging you at midnight or 2 a.m. or 9 o'clock when you're having dinner with the family, and saying, we need to have some, you need to pay us. We're calling you about this debt, blah 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 blah, yada yada yada. Question is, what is the statute of limitations on the debt? Maybe it has expired. If the statute of limitations has expired, then the collector can no longer legally sue you for the debt. So making a payment on the debt will likely reset the statute of limitations, which in our view is disastrous. Okay, so what is the statute of limitations on the debt? A statute of limitation is the limited period of time creditors or debt collectors have to file a lawsuit to recover a debt. So most statutes of limitations fall in the 3 to 6 years range, although in some jurisdictions they may extend for longer depending on the type of debt. And this may vary by state laws, what type of debt you have, whether the state law applicable is named in your credit arrangement. Under state laws, though, there are often legal time limits within which a creditor or debt collector must start a lawsuit or the claim may be barred. So these laws are called statutes of limitation. So if you are sued about a debt and the debt is too old, you may have a defense to the lawsuit, okay? And one thing I also want to say is that in some states, the statute of limitations period begins when you failed to make a required payments on a debt. It is counted from when you made your most recent payment. And the thing is that even if that payment was made during collections, they're still counted from that date. In some states, even a partial payment on the debt will restart the time period. So you want to be very careful here. If you make a small amount, you are restarting the clock. You are restarting the clock. This is why you have to be very careful before actually paying. In most states, though, debt collectors can still attempt to collect debts after the statute of limitations expires. Okay, they can try to get you to pay the debt by sending you letters or calling you as long as they do not violate the law while doing so. However, a debt collector filing or threatening to file a lawsuit after the statute of limitations has expired may be violating the Fair Debt Collection Practices Act. So this is something that you really need to know, okay? So if you are sued, hopefully not, but if you are, it is a good idea to talk to an attorney. It's important that you know you can defend yourself if you believe the statute of limitations has expired on your debt. Reason number 8, a nonprofit debt counselor is available. Big decision time. Let me ask you, big decision time. Do you know what a nonprofit debt counseling agency can do for you? Talk to me. Do you know that? Well, guess what? They could do a lot. And the cool thing here is that they are cheaper, and in some cases, they might be free. Okay? So a nonprofit debt counseling agency can help you pay off your debt faster. They can provide a budget and credit review. They can counsel you to improve your financial health, and they can even help you lower interest rates regardless of your credit score. Think about that. Isn't that beautiful? That's just fantastic. And what we love is that when you talk to a nonprofit debt counselor, they have a constellation of tools that can help you. For example, as you can see on the screen, courtesy of National Foundation for Credit Counseling, and NFCC is one of the biggest nonprofit counselors in the country. You can see that they are saying that a debt nonprofit management plan can help you put, quote unquote, your debt collectors on hold. And by doing that, they can help you improve your credit health. They can stop creditor calls. They allow you to have to negotiate one easy monthly payments. There are no tax or legal concerns. They provide financial education for long-term success, and they sometimes offer affordable solutions. If you want more info about this, please check out our video, The Top 10 Nonprofit Credit Repair Agencies That Help You Fix Your Credit for Free. This is a great video. We have a lot of positive comments about it, so you might want to check it. Reason number 9, a consumer proposal could help. Okay, and what is a consumer proposal? If you have a lot of debt and don't have enough money to pay all your debt in full, it may be a good idea to settle directly with a collection agency. You may want to consider working with a licensed insolvency trustee to negotiate a deal to eliminate all of your debts. What is a consumer proposal? It just basically wipes out all standard unsecured debts. So whether or not this is a viable option will depend on what other debt obligations you have, along with other factors such as, let's say, your income, any assets you may own, or your couple's financial situation. However, if a consumer proposal is a viable option for you, you may be able to pay less than the full amount owing on all of your debts. One thing you need to understand is that a consumer proposal is also reported on your credit report, and then this note is removed for the earlier of 6 years from the date of filing or 3 years after completion. And since a consumer proposal provides a stay of proceedings, it prevents your creditors from recording payments and refreshing the 6-year purge periods on your debt. This means what? It means that each debt included in your proposal may be removed from your credit report sooner than with a debt management plan, and you save money by paying less than you owe. So think about it. Reason number 10, last but not the least, why you should never pay collections, or why you should try to tweak things around. Dragging your feet. So you rebuild your financial life. It's all about buying time, right? I mean, think about it. You have a lot of stuff going on. The family's not working. You have a lot of bills. Cash is tight. You can't sleep at night. You get phone calls from collectors. What should you do? Well, guess what? Drag your feet. Buy time. And trying to rebuild your life. Big decision time. Let me ask you a question. Is that a plausible strategy for you right now? Dragging your feet? Will that work for you? In other words, do you have sources of income coming in so that you can rebuild your balance sheet and later on repay your debt? Remember what I told you before, damage is already done. Whether you pay or not, damage is done. So can you drag your feet right now? Do you want to drag it? That's good. Because if you are trying to build your financial life, then you can just ignore outright all those calls unless you are sued. If they sue you, then you basically want to respond, okay? And another thing is that if you have no income or property and plan to never have income or property at any point in the future, then in this case, you might be willing to ignore the collection calls. Okay, you may want to pay a collection agency though if you owe the full amount of the debt and the agency owns the debt. If you want to resolve the matter as quickly as possible and have the money to do so, if you believe you have a moral responsibility to pay off debts regardless of whether they're actually owed. Okay, so what I'm trying to say is that if you believe that you want to pay the collection agency and you're just trying to drag your feet, then in this case you can either ignore them or you can talk to them and just be honest with them. Be honest, like, listen, I know I owe the $10,000 you are talking about. I just don't have the money now. Or I have it, but I'll probably pay you $10 a month. And after 3 months or 6 months, I'll increase the amount to $20 or $50 or $100. In that case, you can communicate with them. So that even if they want to drag you to court, at least you can show the court that you have actually started working on the issue. Okay, so either ignore 100% or ignore 20%, 30%. The choice is yours. And the bottom line is that I want you to keep in mind that if a debt collector cannot verify your debts, then they must stop sending you collection mail. They must stop contacting you about it. And they have to let credit bureaus know that they actually have to remove the debt from your credit report. Don't let this part slide. Very important. So you want to keep checking your credit report until you see a change. If the debt is not removed, you need to contact the credit bureaus and ask them to look into your case. Again, if the collectors is not playing by the rules, you should report them to your state's attorney general, the FTC, or the CFPB. Thank you so much, folks, for your attention in today's matter. I was talking to you about the top 10 reasons why you may not want to pay collections or charge-offs. Number 1, damage is already done. Number 2, FICO removal is nearly impossible. Number 3, the collector may not own the debt. Number 4, the debt validation letters always rock. Number 5, write a debt verification letter. Number 6, you plan to settle the debt for less. Number 7, the statute of limitations has expired. Number 8, a nonprofit debt counselor is available. Number 9, a consumer proposal could help. Number 10, you want to drag your feet. Thank you so much for your attention. I'll see you next time. But until then, remember, stay marvelous.